you gave about the trial judge. Your testimony was that you thought that you were watching football during the trial.
I know that you're watching football.
Did you put that on the record?
No. This was a judge.
Why would you not put that on the record if you thought that you saw that?
This was a judge who was supposed to be acting as a 13th juror, and if convicted, he was going to be the one to decide upon the jury's recommendation whether to sentence a man to death. I was not about to anger the judge by accusing him of watching football. Not only was that not my role as lead counsel, that was Jennifer's role, but I was not going to take the risk that I was going to anger the very person that was going to decide whether or not to put a man to death.
So you made a decision not to put that forward on the record?
Yes.
Same goes for the comment that you testified to.
Again, that's kind of it's not a strategic decision about a theory of defense. It's not a strategic decision about how to evaluate or approach evidence or testimony or a particular witness. That's a strategy decision about something procedural. It's like a secondary strategy. So here, what Boyanos is trying to like mitigate the issue. It was a strategy decision rather than something that deprived your client of a fair trial. This was a choice that you guys made, but it's really different. It's really not the same thing as saying we chose to go for a third-party culprit defense as opposed to taking an affirmative self-defense approach.
About standing next to Zach with a gun?
Yes.
I didn't think that was relevant to anything. I didn't think it was wise, but I didn't see that as relevant to anything.
And there was another comment you testified to about
when he approached me and told me to get my client to plead to save his life.
and you did not at that point try to put that on the record.
No, I'm not even sure how I would. Would I say, Judge, I just want to put on the record that you improperly approached me and tried to pressure my client to plead guilty to save his life? I'm not even, that was so unusual and so out of norm, something I had never, ever in my life been exposed to. I wouldn't know how to address that with the very judge that committed that behavior.
But how else would you address it? It would be that the only way you could address it would be to address it.
There is a motion to recuse the judge, and the judge denied it. It wasn't for this issue, though.
For the court to put it on the record for the appellate court to review.
I don't know how to address it. I'd never been exposed to that kind of behavior by a judge before. I suppose I could have tried to file a complaint with the board of the judiciary and then anger the very judge that's going to decide whether to put my client to death or not. Again, my emphasis is my client's best interests. So if it was not in my client's best interest to accuse the judge of unethical behavior, I wasn't going to do it.
Your client was convicted in this case. Right?
I'm sorry, what?
Your client was convicted in this matter, correct?
Yes.
And after the conviction, you went to work trying to have the death penalty taken off the table. Is that right?
I had approached Paul Hagerman. I didn't work very hard. He agreed almost immediately. And there wasn't a great deal of deep negotiation or anything. And by the way, to go back to a previous incident of Jennifer Nichols threatening to assault me, I did file an ethical complaint against her for that.
Get her.
You would agree that you achieved a favorable result by getting the death penalty taken off the table, right?
I would not call a favorable result being a client being convicted of something I don't believe he did.